All right, so let's just jump right into the material, and I would like to make sure that you take away a couple key things. So we're looking at attested wills right now, and then we'll look at also the witnessing requirements, specifically about interested witnesses. We'll look at holographic wills, and then finally we'll look at the harmless error rule to kind of close our studies. As you've already taken a look here at wills, wills are documents or instruments, as the legal field likes to call them, and they're instruments that are unique in the sense that these instruments are designed to take effect at death, right? And that's the distinguishing, one of the distinguishing marks or characteristics of a will, is that even though it is made in the lifetime, it is not intended to take effect until upon the will maker or the testator's death. And that is one of the things that I want you to keep in mind as we move through these things, that wills are testamentary instruments, that they are that they take effect upon death. Now that may seem obvious, but what I'm trying to get at is that one of the unique things about a will is that it can be amended and it can be changed and revoked during the lifetime. And we're going to take a look at that more in the coming week, in week 4, when we look at revoking wills and amending wills and what have you. But for this week, I just wanted to make sure that you got that kind of into the back of your mind, because I think that will help make many of the concepts that we're covering a little bit more understandable, and not only understandable but memorable as well. So wills come in all forms, but there, as you're doing your reading, one of the things you'll find out is that the most common form that we're concerned with in law is what is called the attested will. And as you don't look through your reading, one of the things you'll realize about the attested will is the fact that for the longest time in history, there was not a lot of formalities, and so it was really difficult to know whether something was a will or not. Okay, so there was a lot of formalities, as you've read. You know, there was the statute of frauds in the 1600s, and then there was the statute of wills in the 1800s in England, and that carried over to the United States and is very influential into what we have today. So if you were to do a study between the two systems, you find a lot of similarities. But for the purposes of what I want to make sure you take away for this class and for the bar exam, I put them up here on the screen. And primarily, the first thing we want to look at is attested wills. And this is another way you can think of it, is the formal will. It's under Probate Code section 6110, and there are certain elements that must be present in order to have what we call an attested will. And the first one is that it must be in writing. Now that may seem obvious, but for all our intents and purposes, a writing is a physical writing. Currently, California does not recognize electronic wills. And it does not recognize oral wills or video wills or anything of that sort. There is a requirement that must be writing. There was some movement to try to make electronic wills into law. And it was passed, we looked at it in 2019. It actually came before the legislature in 2023, and unfortunately it did not pass. There's still a lot of talk about it. I think we're going to get there eventually. But for right now, an electronic will or an oral will, also known as non-competitive will, is not a valid will. So right now, one of the key features is that it must be in writing, and by that we mean a physical writing. Now, could you make it on a word processor and then print it out? Yes, you can certainly do that. That's how I make wills for my clients, and that's how a majority of people make wills. So it can be electronic in that sense, but it can't live purely in the digital form. That is not recognized as a will under current law. So point number one is that in order to have a valid attested will under Probate Code section 6110, it must be in writing. All right, second point. In addition to the writing, it must be signed by the testator. The testator is the will maker, right? So hopefully you're getting familiar with these terms. I know that it's probably gonna take some time, but the more you use it, the more you get hang of it. So the person who's making the will is known as the testator. And so the testator, the person who's making will, must sign the will in order to be valid. And I think that's obvious, especially in our modern day. We're very used to signing things to make it official. And so the requirement that it be signed by the testator is not something that's foreign. But one of the unique things is that not only does the probate code recognize wills that are signed by the testator, but it can also be signed by someone else, but at the direction and in the presence of the testator. So if for some reason, recognizing that when people make wills, they may not be in the best health, and that there may be other factors that may prohibit them from signing, one of the acceptable manners into which an attested will can be authorized or authenticated is by having someone else sign on behalf of the testator at his or her direction and in his or her presence. Now, there is one caveat, and that this alternative kind of signing is not available for statutory wills, which is actually your assignment this week, a statutory will. So when it comes to a statutory will, it must be signed by the testator. So you don't have this alternative means of authenticating the will. It must be signed by the testator if it is a statutory will. But if it's just your non-statutory will, your kind of your classic, someone made it up on their own, then it can be signed by the testator, or it can actually be signed by someone, essentially an agent, so long as it is at the testator's direction and the testator's presence, then that is also acceptable to be in compliance with 6110. All right, third point is that the testator must also sign or acknowledge the will. So there's either they sign in front of, the testator signs in front of two witnesses who are present at the same time, or he or she acknowledges that the document or the instrument is his or her will in front of two witnesses who are also jointly present at the same time. And joint presence is a key note here. So make sure you don't skip over that, right? Don't just blow over the fact that they have to be jointly there. There are many cases in which there is a dispute as to whether the two people are present at the same time. So the testator either signs the will, but if the testator already signed the will, that doesn't mean that the will is invalid. The testator can bring the signed will to two people who are present at the same time and say, hey, this is my will. And that is sufficient too. So a lot of lay people believe that in order for it to be effective, they must sign in front of the witnesses. That is not true. That may be true for some other documents. So I don't want you to think that there isn't a case for that. There are certainly documents that must be signed in the physical presence. I'm thinking about jurats, for instance, in front of notaries. So if you do an oath in front of a notary, that must be in the presence. Like, you can't sign it until they are in front of the notary. But in this case, the testator can sign in advance and must just tell the witnesses or acknowledge the will in front of the two witnesses at the same time. All right, don't forget that part of it. And it would be a valid witnessing there. Okay. So once the testator has signed or acknowledged the will, or his signature in the joint presence of at least two witnesses, the two witnesses must then sign the will during the testator's lifetime and must understand that the instrument being signed is a testator's will. Okay. And that requirement that it be signed during the testator's lifetime is actually new. It came out of essentially the legislature. The Supreme Court had come upon a case. They didn't like the holding out of the case, and so the legislator added that requirement. Or sorry, the legislature liked the outcome of that case, and so they codified it here in 6110. So that the two witnesses must sign the will during the testator's lifetime. Okay, that's different than the UPC. I don't want to talk much about the UPC, but I do want to just distinguish that under the UPC, it must be a reasonable time And that's not California law. California law says that it has to be signed during the testator's lifetime. If it is not, then the witnessing requirement is not met, and there has to be some other means, possibly the harmless error rule. Harmless error rule, which we'll get to in just a moment. Okay, so those are the essentially the 4 elements. I broke them up in 4 elements. The California Probate Code has them in essentially 2 elements, but I think it's easier to understand this. It was helpful for me when I was doing exams to remember it in this order to make sure I hit every point on an exam. So hopefully you'll find this helpful. These are attested wills, must be in writing, signed by the testator or by someone at the testator's direction and presence. And the testator must either sign or acknowledge the will in the joint presence of at least 2 witnesses, and 2 witnesses must sign the will during the testator's lifetime and must understand that the instrument being signed is the testator's will. If you have all those elements, then you have a attested will under the probate code, and it can be admitted to probate for approving.